Hi everybody, this is Jack Meligan with you again from the Plaintiff's MSA and Lien Solution. Today's video is entitled, Are You Violating Medicare's Rules of the Road? I know, it's kind of a takeoff on Rick Friedman's Rules of the Road, but it's apropos. The reason it's apropos is there aren't a lot of rules when it comes to Medicare because, let's face it, they haven't issued a lot of law. In fact, hardly any. There are no regulations. We haven't even hardly gotten any guidelines on how to do all of this and handle it. But we do have some. And I am just back from New Orleans from the very first MSP Academy meeting where I was one of the presenters. But more importantly, I had presented to me some information that I'm going to talk to you about today that is actually, well, it's earth-shaking. And it definitely points to what can happen to an attorney if they violated the rules of the road as it relates to Medicare. Now, when I say there isn't much rule, there isn't. But one thing we have, and that's been quoted quite often, and you may have heard of this before, but we have what's referred to as the Stalcup memo, written by Sally Stalcup, who is the director for CMS, Region 6 out of Dallas. And Sally wrote this memo back in 2011, but it's pretty concise and it's very comprehensive, and it lays out how Medicare and CMS are thinking about these issues as it relates to billing the Medicare Trust Fund for services related to a plaintiff's injuries and conditions that they have been compensated for and through the form of a settlement. So what are some of the things that Sally says here that are instructive? Number one, she says Medicare's interests must be protected. However, CMS does not mandate a specific mechanism to protect those interests. The law does not require a set-aside, and we've talked about that many, many times. The law requires that the Medicare trust funds be protected from future services, whether it is a workers' compensation or a liability case. There is no distinction in the law. She also goes on to say that each attorney is going to have to decide, based on the specific facts of each of their cases, whether or not there is funding for future medicals, and if so, a need to protect the trust funds. She's referring to funding for future medicals in your settlements. Now, if there is funding in your settlement for future medicals, and most settlements do include funding for future medicals, so unless it's been specifically disclaimed, it's in there. And Medicare and CMS assume it's in there. But here's what can happen. The rules of the road with Medicare are, since 1980, Medicare is precluded from paying for services for your client that are related to the injuries and conditions that are the subject of their settlement, if that settlement includes an amount of money for future medical. It doesn't have to be specifically delineated in the settlement. If it's not disclaimed, then Medicare assumes some or all of the settlement is for future medical. So since 1980, the law is on the books that Medicare is precluded from paying for those services once they discover that your client has had a settlement. There is an exception. Medicare will make conditional payments of your client's bills for services related to the injuries or conditions that are the subject of the settlement. And the condition is they want that money back at the time of settlement. And we all know about this. It's a Medicare conditional payment resolution or lien. And by the way, one of the services that we offer here. So Medicare has strings attached to the money. They will pay those bills, but the string attached to it is they're going to yank it back at the time of settlement. So what is it that I discovered at the meeting in New Orleans that's so important? Well, there has been discussion and speculation, absent any regulations, as to how Medicare would treat bills that they've received for services related to your client's injuries or conditions that were the subject of that settlement that you got them. How would Medicare treat those if they came in post-settlement? what would they do with them? Would they have the right to recover those payments too, just like they would for conditional payments that were made prior to settlement? And for the longest time, the argument's been, no, they wouldn't. But some people have said, well, yes, they would. And then we started discussing and looking in the code to decide where is the authority for Medicare to demand repayment of sums that they have erroneously paid post-settlement. What's their authority for getting that money back? If it isn't the very conditional payment language in the Medicare secondary payer statutes. Well, it turns out that's got to be the answer. And here's why. Here is a letter from CMS, and you might be able to see the date on that. Way up here, March 5th, 2019. This is fairly recent, just a little over, or just a month ago. And this is a conditional payment notice sent to a claimant. And in this notice, Medicare is stating that there have been $200,000 worth of bills sent in, of which Medicare has paid over $50,000 for this particular claimant's services. And Medicare has identified that those $50,000 of bills are related to the injuries that this claimant received a settlement for. And Medicare even identifies the date of the settlement, May 2018, and the amount of the settlement, $1,500,000. Medicare says in this letter, we want our $50-some thousand back. And then they include, and you've probably seen this, they include multiple sheets like this that identify the individual charges and the dates. Now, what is so instructive about this and so earth-shaking is that as you go through the conditional payments that they paid, you can see a definite division in time for the payments they made prior to settlement, which has been traditionally the conditional payments that we're all worried about getting resolved. But the bulk of these payments, 90% of the conditional payments that Medicare is asking for reimbursement out of this letter occurred after the date of settlement and for a whole year or more after that date. In other words, all of the services that this plaintiff acquired to address the conditions, the injuries and the conditions that were the subject of their settlement are in here, and Medicare wants that money back too. This is the first time that we've uncovered this evidence. It has been thought that Medicare would have conditional payments that were due at the time of settlement, and that's true. But here, for the first time, we've got evidence that Medicare counts bills that they paid post-settlement as being paid conditionally, and they want that money back. Now, here's the problem with this. If you ignored this problem and didn't even talk to your client about it, they've just got a surprising letter in the mail. And what if that $1.5 million in this particular case has been spent on paying off a house, acquiring special medical equipment, paying additional bills, maybe modifying a house, getting a new van, new lift? Maybe the money's gone by now. I mean, it's 2019. They got this money in 2018. What if the $1.5 million's gone and now this client is getting a bill for 50-some thousand? And if this were your client and you hadn't warned them about Medicare's secondary payer rights and that this could happen, well, that could result in a very unhappy client and an unhappy phone call asking the attorney, maybe you, somebody you know, what happened here? How come you didn't tell me about this? I don't have the money to pay these bills. How am I supposed to pay Medicare back? And maybe an angry enough client that says, maybe I need to talk to another attorney about what happened. Not a happy situation. But look, it's easily solved. This whole Medicare conditional payment situation and the MSA question, which kind of fits with it, and for that matter, all other types of lien resolutions have gotten very complex. But these are services that we offer to backstop trial lawyers and trial lawyers only, to take this off of your plate, to move the target from you to us, and to completely deal with these and resolve these at the lowest rock bottom dollar that is reasonable and defensible. It's all here. So for those of you who now understand that Medicare can come back after the fact, and that there is no statute of limitations, by the way, on Medicare discovering that your clients had a settlement and coming back for conditional payments that were both, well, the pre-settlement conditional payments should have been paid in settlement, but the conditional bills that they paid post-settlement, they can come back for those anytime and for a large amount of time. I mean, this is just 1 year's worth of bills at $50,000. What if this was 5 years down the road and Medicare discovered that there'd been a settlement and they had been erroneously paying and now they want 5 times as much money? It's a much bigger problem. So, to stop this, you've got to take a look at the rules of the road, and there's one big one with Medicare. It's this 1980 law that says they're precluded from paying once they've discovered your clients had a settlement, and they're going to want that money back, and they're entitled to it. And that means that they're going to come after your client. They may be coming after you. You can fix it. We're here to help you. We've got all the services to resolve Medicare conditional payments, to advise you on MSAs and how to avoid them or minimize them, and to deal with all their lien issues. Give us a call. We're here to help. It's been Jack Meligan for the Plaintiff's MSA and Lien Solution. Back to you again soon.